My Lord, I respect. Yes, I respect Mr. Njiru. He's referring to an application that is non-existent. Either is referring to E554. Mr. Camino, sit down. E554 of 2024, which is before the Court of Appeal, if you are referring to that application. But my Lord, if my learned friend is referring to the exercise of this court of epistolary jurisdiction, then he should say so. But he cannot refer to the exercise of that jurisdiction, my Lord, when this court is functus officio. You have rendered yourself on the question of the application. And therefore, they cannot urge an application unless they say, my Lord, number one, is either served on us, or two, my Lord, because there's already an application for stay under Section 5(2)(b) of the Appellate Jurisdictions Act before the Court of Appeal that is live and that has a date. This court would not have jurisdiction to entertain any other application for stay. They tried making an application before the Court of Appeal this morning using the same issues, my Lord, and the Court of Appeal rejected the application. They were told to serve everyone else. So, my Lord, for my Lord friend to come here and to seek to apply for stay again, having a second bite at the cherry, is dishonest, my Lord. It's dishonest. They are before the Court of Appeal.
So, may I suggest, Professor Gender, that could be your response to the application which will be made by Ndegwa?
Yes, if there's an application, yes.
Thank you, Your Lordship. Your Lordship, permit me to move on with my application, and I urge Professor Ogenda to have a look at the rules that I have just referred to, that Your Lordship, you be kind enough to interrogate the circumstances under which that office shall be filled. Your Lordship, it is on record, and I invite the court to take judicial notice, that there is a clear non-existence of a crucial state organ that is supposed to oversee the processes of filling of that office in the name of the Independent Electoral and Boundary Commission. Your Lordship, the Independent and Boundary Commission is created under Article 88 of the Constitution, and the functions are created therein. One of the functions, my lady, is to maintain a voters register, is to register voters. Under Article 99, Your Lordship, of the Constitution, as read together with Article 137, creates the qualifications upon which the President or the Deputy President must attain if one is to hold office. My ladies, my lord, it is clear that the functions created under Article 99 of the Constitution can only be executed and or implemented by the Independent Electoral and Boundary Commission. It goes without saying, my ladies, my lords, that a deputy president designated or nominated must attain those qualifications. That is to mean, my ladies, my lord, that there must be an organ that will give a clean bill of health to say or to suggest that Professor Kithure Kindiki attains these qualifications. My lords, my ladies, I refer to the memorandum that was sent to the Speaker of the National Assembly by the President of the Republic of Kenya, dated the 18th of October 2024. In that memorandum, Your Lordship, the President drew the attention of the Speaker to the clearance of the designated candidate by the IBC. And this is what the President had to say. Your Lordship, the President indicated that he has had confirmation that Professor Kithure Kindiki meets and attains the qualifications created under Article 99 as read together with Article 113 of the Constitution. My ladies, my lords, when the President of the Republic referred to the IEBC, and I call upon the court to take judicial notice of that document, it was a presumption that that confirmation was done by the Electoral and Boundary Commission as created by the Constitution. My ladies, my lords, it's my humble appeal that this honorable court does fight in my favor to issue the conservatory order on the basis that there is no clearance that has been issued by the IBC.
My lord,
we all know, my ladies, my lords.
My lord, may I kindly seek your guidance? When Mr. Giro started off, we thought it would be a simple and a straightforward application. But now, seeing the trajectory it has taken, he has raised an avalanche of issues for which we would require them reduced in a particular format so that we can seek instructions from our clients. So we'll be seeking that we get a formal thing that will enable us to seek instructions from our clients. Dr. Kamodo, for the 10th respondent.
Your Lordship, I am making an application on the basis of the law. Your Lordship, if it is not crucial for us to have an IBC to confirm whether Professor Kithure Kindiki is a registered voter, that would mean, Your Lordship, that a person can go to Mathare Hospital and designate a person to become a deputy president. The qualifications created by the Constitution have a mechanism of being established, Your Lordships. And the process of establishing those qualifications, Your Lordship, is set down and out in law. Your Lordship.
Mr. Njiro, my understanding,
yes, Your Lordship,
when you first asked for this conservatory order,
yes, Your Lordship,
under Madu paper,
yes, Lord. That is his application. Yeah. I have on a different application. I moved under 23 section.
Because my understanding is that if you want the court to give conservatory orders immediately after rendering a ruling or a judgment, that application can be verbal but also very short, because the court is already aware, has already expressed itself.
That's correct.
So that kind of application cannot be the beginning of another big
Your Lordship, I am well guided.
So I think for the purposes of the discretion of the bench, for the purposes of the discretion of the bench, yes, I think Mr. Ochieng's application is what we should be considered. Your application evidently requires to be formal.
Your Lordship, I am well guided by the court, but the court also needs to perhaps appreciate the import of Rule 24. That due to the vulnerability of the rights and the vulnerability of the infringement and the violation of the Constitution, I can appear before you.
Rights cannot be vulnerable. Individuals are.
May I have my time and then you have your response, Professor? Your Lordship, this application is premised again on Article 3. The call upon every person to protect the Constitution. And as I pen off, it is all clear to us that nobody can deny, not this court, not myself, nobody can bury his head under the sun, that there is no IBC. If Kithure Kindiki is to be sworn in tomorrow, what will be the import of swearing in a person who has not been verified and approved by the organ that is supposed to do so? Finally, Your Lordship, can this court fold its hands and watch and midwife and babysit a violation of the Constitution? What is the role of the court when it comes to the issue of Article 3 of the Constitution and the question of the sovereignty of the people? Your Lordship, I beg that you hear us. I beg that you grant the conservatory order staying the swearing in of Professor Kithure Kindiki on the basis that he has not qualified to hold that office. Secondly, on the basis that his purported qualification has not been verified by the body that is mandated to do so. In the absence of that, Your Lordship, you will be inviting us to say that even an insane person can become deputy president, a bankrupt person can become deputy president.
Objection.
I rest my case.
My lord, let me respond to... can I respond?
Professor Agenda and,
yes, my lord,
and every other counsel who is seated, please sit down. We have two applications, and this is not going to be a start of another court process. It's not going to be a start of another court process. The applications which have been made are discretional. So I'll only allow one response, and then we'll render a ruling. Only one response.
My lord, if I may respond, my lord.
My lord, kindly, with your permission. With your permission.
My lord, we've made a ruling.
Okay, let me hear two people from this side.
Okay, then two from... You're one person.
Dr. Kamimla, please say what you want to say and be mindful of time, please.
Yeah, I want to take my time. Justice Eric Okola, Justice Andrew Murima, and then Justice Frida Mukanzi. I've listened to what you have said very carefully. And from my point of view, one who is interested in developing the students of the country, you have done so. You have developed the students of the country. But there is one thing I would like to point out to you very respectfully. That we are operating in very dangerous waters with strong currents. And this is an area where we have to call for wisdom. We have to call for deeper understanding of human nature and for deeper understanding of the society in which we live in Kenya. And what I'm saying to you is reflected in my broad feeling of the authorities in the cases in the United States of America. Your Honor, if I may say so with respect, perhaps more than anybody else, when I was engaged to get involved in this case, I ordered for books from India straight about electing bodies or impeachment. And I've taken the trouble to read them day and night. And one thing that has emerged from all these authorities when I was reading them very carefully is that the court in the United States have continued to think very carefully how will this judgment be received by the people, by the consumers. How will it be received? Is it a judgment that will continue to promote stability in the country? Is it a judgment that will continue to promote the rule of law? Is it a judgment or ruling to promote stability in the country? And it is here that I'm inviting you very respectfully that you consider the able remarks of my learned friend, Mr. Gachagua, that we should not, and my friend Mr. Here, we should not ignore what they are saying lightly at all. With a tremendous respect, we don't want to move out of this courtroom and then all of a sudden we are told that they are protests now in such as in I'm not trying to criticize anybody at all. All that I'm saying to you,
Sorry, my lords. The utterances by the Honorable Hamino, Council, I'm giving you the titles.
No, what I'm saying, let me say what I'm
Unfortunately, they're inciting, they're insightful, they are trying to preempt matters that are not before this court. We do not know and we cannot speculate that anyone is going to be happy or unhappy about it. The sword of justice cuts both ways. There are those who are going to be happy, there are those who are going to be unhappy. That is how life is, but you cannot incite by saying from here, we will have protests, we will have what? We do not know of that. And unfortunately, my lords, I ask you to kindly restrain him from taking that route.
With your kind permission, Your Honor.
Please sit down. Please sit down. We want you to know that we have rendered ourselves in this matter. We have rendered ourselves in this matter, and we are not going to open this matter for a further court proceeding. There are two applications before the court, one by Dedlo Chieng and one by Ndegwa. After Dr. Kamuna has spoken, we'll allow two people to respond, and then we'll make a ruling.
I know that was indicated that two people, and I was prepared kindly to make an application.
Continue, Dr. Kamuna.
Yeah, my lord, I'm actually showing one sentence. When you read the rules, I have referred to authorities in America. The judges have made a finding among themselves. Yes, this is a bit of so and so is guilty. But we shall not go ahead. We shall do it. So that's all I'm saying to you. You have heard, you have come up with a very, if I may say so, a ruling full of jurisprudence, and particularly my land, Lord Gachagua, has come up with something that I had not thought of very much at all. But all I'm saying to you, that you are big, but you still have the discretion to say that, look, we are not, these are our findings, but still we are going ahead to give conservative orders for so many days or so many weeks. So you still have that discretion for the sake of the country. Thank you.
Response.
I appear for the 9th petitioner in the second cohort. My Lord, I stand to make an application for stay of the orders that have been issued this afternoon relating to the application that was before you, and having keenly listened and internalized the import of that ruling or order, my Lord, we wish to move the court, much as we have that opportunity by way of the orders that were given, that we were given right to appeal, that pending the appeal, pending the lodging of the appeal, my Lord, my Lords and my Lady, you allow us that opportunity of stay so that we can ventilate our issues before the appellate court. My Lord, what informs this application is that there is an apparent risk by the fill-up of the position of the Deputy President, and in our petition we had named the Professor Kithure Kindiki as a party in the petition that we had filed for the 9 petitioners. So that, my Lord, having analyzed and internalized that, we feel that the petition, in the fullness of time when the court is going to process it, we will be dealing with an issue that perhaps will compromise the rights of the 9th petitioner who has moved the court. And, my Lord, the other issue is that there is a period within which the respondents, if they have to move, they have to fill up that position of the Deputy President. So that, my Lord, there is no any prejudice that will be occasioned to the second respondent if the orders of stay gets issued, because by close of business today, my Lord, we are going to lodge the notice, and that notice by itself acts as an appeal, and in the fullness of time we shall be processing the application before the appellate court for appropriate orders to issue. My Lord, I therefore associate myself with my colleagues on the application for stay so that we don't have the proceedings before you in the fullness of time when we come to canvass the petition to be rendered nugatory or academic. My Lord, you have the discretion, and we ask and beseech you to exercise that discretion in the favor of the 9th petition. Thank you, my Lord.
My Lord, I would like to make an application under Article 1.1 directly. My lady. My lords and my lady, we are thankful for your ruling today and the lengthy explanations and court case that has gone into it. Unfortunately, my lords and my lady, it seems that some people are being favored over us, and in this matter, it is the state or advocates. We are here acting in person, and we are entitled to the same equal protection of the law. We are here trying to defend the Constitution and our constitutional rights. I am being discriminated against as a woman, as a person with disabilities, and as a youth, my lords and my lady. We filed our application on the 8th of October 2024, and we thought that we'd be enjoined as interested parties to participate in Tuesday's proceedings, but we were not. So we did not have the time to ventilate our issues properly. My lords and my lady, we are asking you to stay your orders for 7 days, as you have told us to come back on the 7th of November, so at least we get a fair chance, a fair fighting chance as a sovereign to also ventilate our issues properly. The state cannot override us, and advocates cannot override us, my lords and my lady. This is a court for equality, and we are asking for equality. My lords and my lady, we also appreciate that Rigathi said has asked for 7 days to appeal. Kindly consider us in, because there is no point in justice. It will be granted to some petitioners, and others will just be thrown under the bus and into the darkness. Thank you.
My Lord, if I may respond, my Lord.
Sorry, just a minute. Can you just clarify your application? You say is dated the 8th of October?
8th of October,
What is the
2024.
substance of your petition?
It's petition E541 of 2024. We were seeking stay orders to stay the proceedings in the National Assembly based on Article 32(1), freedom of conscience, and Article 33, freedom of expression.
Maybe with your kind permission.
Let me clarify. Is that the matter in which you are appearing with Dr. Bosso?
Yes, my lord.
Yes. Now, if you have been following the directions of this court keenly, we have been issuing various orders on consolidation. And I can assure you, I did that. And you and Dr. Bosso are petitioners in one of the cohorts. I think it's cohort number 1. Yes, it's cohort number 1. You are petitioners in cohort number 1. And we directed everybody to get into the CTS system, and whoever has a problem to get in touch with the deputy registrar. So it is not right, Ms. Wanjiru, to claim that you have not been enjoined in these proceedings. You have been enjoined, you are a party, and that is why we allowed Dr. Bosso to address the court, even yourself to address. So you are a party. You are a party. That one I can assure you.
My lord, we were not entitled to the right of enjoinder, and we had points that we wanted to defend against the respondent side. So we're just finding it very difficult that due process is not being followed in our instance, as we applied even before both parties on the 8th of October 2024. They came to court on the 18th, 10 days after us, and they have still been granted audience before us, and we were told we're going to be in cohort 1, and then cohort 1, this application has already overtaken cohort 1. We're now being told to come next week, after the swearing in would have been gone through, and after numerous rights would have been violated that we have raised.
I think, Ms. Wanjiru, what you just need to do is just get into the CTS, get all the directions. There's every direction. There's a reason why we came up with cohort 1 application petitions and cohort 2 applications.
Yes, my lord.
So I think we may not wish to respond on whether you are discriminated or not, but we are so sure you are not discriminated, because there are proper directions in respect of every cohort and every matter before us. Kindly take time to go through the CTS.
My Lord,
Thank you. This court had made directions on this issue. We said there are only 2 applications before this court right now, and those are 2 applications which will be responded to. We have applications. We are finished with this side.
You have not spoken on behalf of the second petitioner.
My Lord, we would like an opportunity to respond to both applications that have been brought today.
Maybe I can say one thing, just on behalf of the second petitioner. My name is Kimoto Teresia Wanjiru, Makazi. Yes, there's Kimoto in company of Mr. Goya. I just wish to say we welcome the ruling. However, there are some bits that we feel aggrieved and we wish to appeal. And therefore, as we do the notice of appeal, we are praying that we are in support of the issue for injunction, no the issue for stay, which the court may say it's a negative order, but we are saying pending the time we do the appeal, at least the status quo be maintained. And also we wish to say that there was an issue that the Court of Appeal today dismissed an application for stay. That is not true. We were told to serve, parties were not all served, and that's the reason why we were given another date. So therefore, we are in support of these 2 applications that have been made today.
Thank you. Let's also, Mr. Dr. Bosso, please sit down. Please sit down.
My Lord,
please sit down. Please sit down.
Will I be given a chance to speak?
Please sit down. Ms. Wanjiru, proceed.
Yes, my Lord. As a young woman, I'm under 35, my Lord. I'm actually 35. I'm a youth and I have a disability. And we're the only ones, I think, on the platform that check that we have a disability, my lords and my lady. Our Constitution, Article 1.1, has to count for something. Because it was intended for us to come to court directly.
Please respond to the application. Support, make the application.
Yes, my Lord, I'm in support of the application. Mr. Vice.
My Lord, finally. My Lord, in response to the 2 applications, you want to also an application? Yes, my Lord, in response to the application by my learned friend, Mr. Ochiel, future senior counsel, and my learned friend, Mr. Ndegwanjiro, I wish to say it as follows, my Lord. My Lord, number 1, the Matthew paper order sought by my learned friend fall on the basis of the following principles. Number 1, my Lord, there is already an appeal that has been filed in the Court of Appeal and an application for stay under Rule 5 to be filed, being application number 554 of 2024. The Court of Appeal is therefore seized of this matter, already seized of this matter. In those circumstances, my Lord, a party can only apply for stay in the Court of Appeal. That's point number 1. My Lord, point number 2, ordinarily, when a court delivers a ruling in a matter, the court becomes functus officio in respect of that particular matter. My Lord, that matter therefore, or the applications made are therefore res judicata in the sense that a determination has been made, and this court cannot go back and approbate and reprobate at the same time. You cannot deny an order and then purport to issue the order again. Point number 3, my Lord. My Lord, Rules 23 and 24 of the Mutunga Rules as presented before you, together with an application by my learned friend on substantive issues touching on actions that may be undertaken subsequent to this, including, my Lord, the qualifications of the Deputy President nominee, Kithure Kindiki, can only be brought to this court, my Lord, through 1, either a new petition and a new application, or 2, my Lord, through an application for review The only avenue that Mr. Ndegwa can bring all the issues that he has spoken to this afternoon are applications through review. No application for review or setting aside has been filed before this court by Mr. Ndegwa. And therefore it is inconceivable, my lord, that this court would entertain the application brought on several grounds, my lord, including grounds challenging the suitability or otherwise of the Deputy President nominee. My lord, lastly, and because my learned friend will submit further, once a court has delivered a ruling, my lord, the justice of the cause is that consequential processes can be undertaken given that there are no orders in place. And that is not for the court to be part of or to control. That is for other parties, probably not before this court, my lord. My lord, what you have done is dismissed the application of conservative orders. So that's a negative order. The court cannot be invited to review or to stay a negative order that has dismissed an application. And the negative order again goes to the application by Kimotho and Company Advocates from Kerugoya, who has also sought to stay your orders, yet all that application had, my lord, was for the former Deputy President, former underlined, to apologize to NIS. Surely, Kimotho, you can do better. My lord, I'll invite my lion friend to go.
You are protected. You are protected.
Mrs. Kimotho and Company.
Yes, my lord, my name is Muzomi Yankolu for the second interested party. I have listened very keenly to the two applications, and the issues for you to weigh in your mind are as follows. One, if the outcome they seek through these two applications was declined by the Court of Appeal, not yesterday, but today morning, can this court, being a court lower than the Court of Appeal, on the very same day be seized of an application that result in the very outcome?
Lordship, may I quickly bring it to your attention that counsel has a duty to this court to speak the truth. Being an officer of this court, being a doctor and a teacher of the law, he understands the duty that he has towards you and towards the law, and the fidelity to the law. It is not true that an application was dismissed. It is true that parties were told to serve. So let him submit on the premises of facts and not the premises of presumptions and with the intentions to mislead this court. And if it was declined, let him bring the orders.
My lord, I think it's an issue of semantics. I come from a community that is not an expert in the English language, but whatever you call it, the point is this. The effect of you granting either of the two applications would be to contradict a decision by the Court of Appeal today morning, not to grant similar applications. That cannot be denied in good faith.
We are objecting to this. They are misleading. I was before the Court of Appeal.
You were in a car in the morning.
My lord, the Court of Appeal is a court of record. I don't want to belabor this point. Let me move to my next point. The Court of Appeal is a court of record, and I'm sure the court has access to that record. Two, my lord. It is not like Kindiki was nominated yesterday or the day before yesterday. He was nominated several days ago. If the application now being made were made in good faith, they should have made a formal application several days ago, which would have been on record, which you would have had the opportunity to respond to. You are now being invited by submissions from the bar without a formal application to grant some relief, supposedly on the ground that Kindiki is unsuitable. That cannot be proper, my lord. especially when the nomination of Kindiki wasn't made yesterday or last night. They had noticed for several days. If they have any issues with the suitability, they would have filed an application on that regard, or even amended the applications we just determined, and they were granted that leave. And they didn't amend them. So surely it's an ambush for my colleagues now to stand up and start telling you Kindiki this, Kindiki that, and therefore stay, and therefore Madu paper this and that. 2. Number 3, my lord. What you're being asked to do is to flip-flop or to behave like a pendulum. My lord, a pendulum moves from this end to the other end, but it never leaves the two extremes, so there is what I usually call motion without movement. The court has already read a ruling to us saying that it cannot issue a conservatory order that would have the effect of suspending any provision of the Constitution. You're being invited right now to do exactly what you have just told us cannot be done, and you're told the reason you should do that is because you're human and there is a possibility you're in error. Of course there is a possibility, my lord, you're in error, but there is a court that exists to correct errors made by this court. You're being asked to embarrass yourself, to say just a few minutes ago that the conservatory order should not have issued in the first place, and then you're being invited to issue an order that would have the contrary effect. I think they are setting up the court for embarrassment. My lord, there is a reason, there is a law which we all know because both the people in the bench and the bar are lawyers. And it is common ground that no appeal operates automatically as a stay of any decision made by any court. The reason that rule exists, my lord, is so that whoever is desirous of an appeal can move the appropriate court, which they have done, and persuade that appropriate court to issue that stay. So they are telling you because there is a possibility you might be in error, therefore automatically, but the rule, if I understand it, is that no appeal, let alone an intention to appeal, can issue automatically. Lastly, my lord, you have been told about the Madu paper injunction. I thought we were talking about conservatory orders, my lord, because Munya told us injunctions are remedies in the realm of private law. They exist to protect personal private interests, and conservatory orders, which you just said cannot issue in the circumstances of this case, are the remedies available in public law for the ordered functioning of public agencies. And because, my lord, they said this court has jurisdiction, if eventually you find that the Honorable Rigathi Gachagua was not lawfully impeached, this court has still confirmed it has a remedy. It can undo the entire process. Let us not detain you here, back and forth, flip-flopping, behaving like a bedlam. It is holding the court at ransom, in my view.
My lord, if I use only 2 minutes in the joint of the court, permit me.
You will respond after Peter.
Yeah. My lord, I'll just take 2 minutes to mention something which will be in addition to our case. My lord, Article 10 of the Constitution outlines the doctrine of rule of law. My lord and my lady, the doctrine of rule of law anticipates that at some point controversies in the society, especially legal controversies or controversies related to the interpretation of the Constitution, will be determined by judges. And concomitant to that is the doctrine of finality of your decisions. And more importantly, the public policy in terms of consistency in judicial decision making. But my lord, my lady, once you've made a decision, the expectation of the public is that you will stand by that decision unless there are exceptional reasons for you to depart from the decision. Especially immediately after you've rendered your decision, it will undermine that doctrine of finality of judicial decision making. If you immediately depart from the decision without exceptional reasons, they have not put on record exceptional decisions to warrant that immediate departure, and the public expects that your decision will be enforced. Secondly, the doctrine of rule of law again operates in a complete way. John Locke in 1689 developed a concept in his treatise of government known as the concept of inalienable right, which informs our constitution. And one can mention here that judges have a right to be wrong. They say you have a right to be wrong. We have listened to your decision, and we believe that the reason why conservatory orders cannot be continue is a heavy public interest reason of the need for the vacancy, for there to be no vacancy in the office of deputy president, and the constitution does not anticipate that. So in conclusion, they, under the provisions of Article 164(3), they based on the way the rule of law works to model the fabric of the society, they have the right to appeal. My lord, you have granted that right in your ruling, and from where we stand, we submit that they cannot, on this matter of immense public interest, where you've made a decision for them to seek to make an application from the bar to upset a decision which you have rightly pointed out is meant to fill a major constitutional gap in respect to vacancy. And lastly, the right to be heard. The right to be heard is very central. Mr. Ndeganjiru has made factual statements in this matter in his oral application. Again, given the immense nature of this matter in terms of public interest connotations, it is important that the respondents are given opportunity to specifically rebut the factual questions of law, the factual questions and some of the legal points that they are brought up. So in that case, if they really want to move this court, then we will submit that the proper way is to make a formal application so that we are hard on that question. Thank you.
Your Lordship, the IEBC, the second application was directed at us. Everyone seems to have said something except the IEBC. And I just want to make two small points. Number one, as it relates to the application by Mr. Ochiel Dudley, my friend, first, Madhu paper was pre-2010 constitution. That is important for the court. It was a commercial matter relating to restitution. So it was a remedy in private law, not in public law. Madhu paper was pre-2010 constitution. It was a commercial matter, a restitution in private law. So this will not apply. The second issue, application by Mr. Ndegwa, Learned Counsel, I am looking forward to reading the decision of the court, because those were issues that we were on our feet for 30 minutes arguing about, the role of IEBC and what needs to happen. So already the court has made a decision on that, and likely the answer will be in the ruling that the court has already read. Third one, and most importantly, I want to point to the court the case of Eliud Matindi and two others versus the President of the Republic and the PSC, E084 of 2023. It is the CAS matter. And it feels almost like deja vu that Ochiel Dudley is here making this point. We lost that matter in the High Court. The court made a finding that the offices of CAS were not constitutional office. We were on our feet for a long time trying to urge the court to give us a Madhu paper injunction. And the court said, If the issue related to constitutional compliance or constitutional infraction, as the court has already noted, that the position of the Constitution must remain operational from the decision of this court, then that injunction will not apply. The remedy is for the parties to apply to the Court of Appeal for an appeal or a review of that decision. So those three things can clarify those two issues for the court. We think these applications are not merited, and the court and the parties should put more effort in their fight to the application. Thank you.
Perhaps before senior speaks, maybe we get directions as to how many they are responding, because there was that limitation on this side, and we were restricted as the petitioners. If the court could give directions as to that.
Let Mr. Moses speak.
Thank you, my lord.
My lord, you have not given us directions as to how many of them should address you. Considering that the petitioners were restricted.
We said two. Three of them have already spoken.
My lord,
Mr. Moses, nothing stops you from saying that you adopt the position of your predecessor.
That's correct.
Yes.
My lord, I want to say that I associate myself with the sentiments by my colleagues, but I want to add, my lord, that you have given a detailed and a very comprehensive analysis of your ruling. You've gone into graphic details, and you have addressed various issues and given a determination on the same. We are not before this court, my lord, to litigate in installments. My learned colleague, Mr. Ndegwa, has all along been aware that Professor Kindiki was nominated. For him to just spring up now and start raising issues concerning Professor Kindiki is just but a mockery of the justice system. My lord, you've made a determination. You have thanked us official. We will not want you to reopen these proceedings again. They have known and available avenues to them. Let them proceed on those avenues. I submit, my lord.
Thank you very much. On only one point, which I actually objected to when it was being made, the point was that how would Kenyans receive the decision? I'm not so sure whether this is what these applications should be based on, because whichever way, there will be parties that will be aggrieved by the decision. There are many others that will be satisfied. Do not be misled that there would be protests, just the way I also cannot mislead you by saying there will be jubilation and celebration everywhere. The position remains, the court has rendered itself in a decision, the court is thanked us, and therefore we have now to move on. Any party aggrieved knows what to do, which is either to appeal, apply for a review, variation, or whatever it is they have to apply for. If the processes that will take place after this would be contra the Constitution, every party knows what to do, and this court is still seized of the matter, and they will be coming over here for a pronunciation on what the constitutional rights are. Therefore, we should actually not be taking the route that the decision may be popular or unpopular. It's a decision of the court, and it cannot be challenged along those lines.
Thank you. My Lord, honoring the court and my colleagues' time, this is my rejoinder in exactly 2 minutes. My Lord, Rule 32.2 of the Mutunga Rules allows us to make this application informally as we make it. Rule 32.2 of the Mutunga Rules allows us to make a Madu paper application as we do. It says the application can be made informally immediately after delivery of the judgment. Rule 32.2 Mutunga Rules. My Lord, this President, the Attorney General when on the other side has many times sought a Madhu Pepper injunction. In the Finance Act litigation, where my friend Mr. Somane was present, Justice Majanja presiding, this court, in this room, issued a Madhu Pepper injunction. My Lord, on the last point, my learned friend Mr. Ojenda sounds familiar with the Madhu Pepper case. It's a Court of Appeal decision. And you saw the first one, Bat versus Rent Tribunal. It is one of the most cited cases on the question of stay. And in that case, the Court of Appeal said, my Lord, allow me to read, and then I'll sit down. There is no inconsistency in granting such an injunction, a Madhu Pepper injunction, after dismissing the motion. The purpose of the order is to prevent the Court of Appeal's decision from being rendered nugatory, should that court reverse the High Court's decision. The respondents concede that you could be wrong. There's human infallibility. The purpose of the request we make is to respect that issue. What if you are wrong and you allow the wrong person to come into the high office you've just established? My Lord, allow the request for 7 days. Thank you so much, my Lord. And my Lord, may I just clarify that our application is distinct. We do not seek stay, we seek an injunction. Thank you.
And I'm interested in the event my Lord is allowed. Can we also move you again to remove it?
My Lord, I think in view of Article 50, they also have a right to make that application. Your Lordship, allow me to draw your attention to Article 149, Clause 1. That London is not burning, and that a vacancy is contemplated, and actually a vacancy of 74 days, within which due process ought to be initiated to ensure that a rightful person, fully qualified, fully known in law, fully appreciated by the law, takes over office. Therefore, this vacancy is a constitutional vacancy. Further to that, Your Lordship, permit me to address you that this is a new application and this application has not been determined. Further, allow me to indicate that I listened pensively to the three thematic issues that were raised by the court, and this is not one of them that was raised and resolved by the court. Finally, Your Lordship, we all have a duty to uphold the law and to defend the Constitution. On the 16th of October 1953, Fidel Castro had this to say in his defense, that history will absolve me. History will absolve the petitioners. That we have brought to your attention that you have the duty to protect the Constitution, that a person qualified should take over. I'll wait for the ruling. Finally, Mr. Somane has not addressed you on the qualification and the ability of a person to meet those qualifications under Article 99 and Article 137. He has not even told you that they are not applicable. If the court wants to say they are not applicable, history will absolve me. If the court wants to say that has no power to defend the Constitution, history will absolve me. If the court wants to pave way and mutilate this Constitution, history will absolve me. If the court wants to midwife an injustice, history will absolve me. I am most obliged.
My Lord, Samyaberi for the ninth petitioner. Only two issues. I invite you to Article number 23 of the Constitution, which gives parties rights to come before you. 23 of the Constitution, which allows parties to come before you to seek for reliefs. And in this instance, We are seeking an injunction by way of a stay, albeit temporarily, of the orders that this court has issued. And we are not seeking these orders in eternity. We are moving into the appellate court once we have the ruling. Number two, my lord, I invite you to the application by the 9th petitioner, the notice of motion application dated 18th of October. Because there was an allegation that we have been sitting here and it's coming as news that Professor Kithure Kindiki has been nominated to take over the VP position. My lord, that notice of motion application speaks to the application that we're making, that it was seeking for a conservatory order, and the court has rendered its decision. So we are inviting you kindly to exercise your discretion so that we may have that application processed before the appellate court if it is found of merit, so that we don't have to have it as an academic exercise. Thank you, my lords.
May it please the court. My name is Dr. Eboso, and my co-petitioner had made a similar application that you, the Honorable Court, be pleased to stay the order that it has given today. And the respondents have raised an issue that Professor Kindiki was nominated over a week ago, and that if we were raising this application in good faith, then we ought to have raised it earlier. I wish to refer the court to its directions, which made it clear that one, the only applications it was going to hear were the two applications that were before the court, and this was made despite protests that my co-petitioner and I have raised for the last 2 weeks, that we have applications that seek similar orders and they've not been heard. However, I also would wish to direct the court to its own directions, which directed that we file amended petitions because many of the petitions had been overtaken by time. And if you look at our petition as amended, we actually raise concern about the process of election of the deputy president designate in our amended petition, and so it is quite in substance and whatnot. Secondly, I'd like to point out that my co-petitioner pointed out that we have been feeling discriminated, and as she explained earlier, she's dyslexic, and sometimes she might rush her words, especially when she's tense. The feeling of discrimination that we've been having is that out of all the petitioners, we are the ones who have consistently for the last 2 weeks called on the court to refer to the applications that are before it, and that which touch on this, and will be given adequate time to ventilate them. Yesterday, I agree, we were given an opportunity to speak as interested parties, and after the respondents gave their case yesterday, I tried to catch the attention of the court, and I was ordered to sit down. I wasn't rising because I don't have a right of response. I know that. I was rising because I sought the discretion of the court, specifically because there are specific 4 issues that the respondents raised against the things I had raised. And in the decision of the court today, which I have listened to, one of the issues has actually turned on that. The fact that this court believes, which I believe is wrong, that it has jurisdiction to reverse the assumption of office of the deputy president. Of course, you've given a ruling and we respect it, and we wish to appeal that ruling. However, now we are asking the court, because both the respondents and us applicants agree that we have moved the court of appeal, and the court of appeal has given a mention date. So the court is aware of that, or at least that is not disputed. We are asking the court to stay its decision today, allow us to move the court of appeal appropriately, so that it can give the necessary orders as relates to that, even if it means correcting what we believe to be the wrong finding of the court. The idea that this court is functus official does not arise, because the rules of the civil procedure, I'm not sure which rule exactly it is, allow any court, after giving its judgment, allows a party to ask for a stay even informally and the court to grant it. So really the issue of functus official does not arise. Thank you very much.
Thank you. We will adjourn for 20 minutes. We'll be back at 5:30.
Mtazamaji wangu, hayo ndiyo yameweza kujiri pale Mahakama Kuu ya Milimani, ikiwa ni kwamba jaji ama majaji hao watatu wametoa mwongozo kwamba Kithure Kindiki, naibu rais mteule, sasa anaweza kuapishwa. Wameondoa vizingiti ambavyo vilikuwa vimewekwa hapo awali katika mahakama hiyo. Kuna vile vile mahakama ya Kerugoya. Ni rasmi sasa kwamba vizingiti vya kisheria ambavyo vilikuwa vimeombwa na naibu wa rais aliyeng'atuliwa Rigathi Gachagua vimeweza kuinuliwa, vimeweza kuondolewa, na sasa huyo naibu rais mteule Kithure Kindiki ana kila nafasi ya kuweza kula kiapo na kuapishwa ofisini. Ni mwongozo ambao umetolewa muda si mrefu na majaji wote watatu, Eric Ogolla, Anthony Mrima na Daktari Freda Mugambi. Mtazamaji wangu, ni kwamba kufikia sasa ni rasmi kwamba Mahakama Kuu imeondoa vizingiti vya kisheria ambavyo vilikuwa vimewekwa katika Mahakama Kuu ya Milimani, vile vile ile ya Kerugoya, ya kuzuia naibu rais mteule Kithure Kindiki kuweza kuapishwa ofisini kama naibu wa rais. Ni malalamishi yaliyofikishwa pale na naibu wa rais aliyeng'atuliwa kupitia bunge Rigathi Gachagua, na sasa ni kwamba hatma ya Gachagua imeweza kujulikana. Jaji Eric Ogolla, Jaji Anthony Mrima na Freda Mugambi wameondoa vizingiti vya kisheria. Imekuwa vile vile ni sarakasi pale mahakamani baada ya majaji hawa kutoa mwongozo huo. Mawakili wa naibu wa rais vile vile wameweza, naibu wa rais aliyeng'atuliwa kunrathi Rigathi Gachagua, wameleta maombi mapya na maombi ambayo wameweza kujibizana hapa na pale kati yao na upande wa serikali, na kufikia sasa ni kwamba jopo hilo la majaji tatu limeomba dakika 20 waweze kusemezana pembeni na kurejea na mwongozo. Je, majaji hawa watatu watatupilia mbali maombi haya ambayo yamewasilishwa rasmi na upande wa naibu wa rais aliyeng'atuliwa Rigathi Gachagua, ama watasisitiza kwamba hamna kesi hapo na kwamba vizingiti vyote vya kisheria vimeweza kuondolewa? Kumbuka bado tuna wageni hapa studio, ni Javas, mwanasheria ama mchanganuzi wa kisheria, na vile vile Joe ambaye ni mwanasheria. Pengine tuanze na yaliyojiri pale mahakamani. Tulimwona huyu Jaji Ogolla akiweza kusoma kwa lugha ya Kizungu, tena akitumia Kizungu ambacho Mkenya yote anaweza kuelewa, akisema vizingiti hivi vya kisheria, conservatory orders, zimekuwa disallowed, zimeondolewa. Ni nafasi gani kwa Kithure Kindiki kisheria? Javas.
Kwanza, kitu ambacho kimedhihirika wazi kimsingi katika uamuzi wa Mahakama Kuu ni kuwa katiba ni sheria mama ya nchi na kuwa mahakama ni zao la katiba hilo, na katika kuzingatia mambo kadha ambao ni ya kimsingi pia kwa misingi ya haki, katiba imeweza kuondoa ile amri ya kihifadhi ambayo ilikuwa imewekwa haswa na mahakama ya Kerugoya, ambayo ilikuwa inazuia kuapishwa kwa Profesa Kithure Kindiki kama naibu wa rais wa nchi. Jambo lingine, mahakama imeweza kusema kwamba kusudio la katiba sio kuwepo na mwanya katika afisi ya naibu wa rais kwa sababu kuna majukumu ya kikatiba ambayo afisi hiyo imetwikwa, na Wakenya hawawezi kaa bila naibu wa rais kwa sababu sio kusudio la katiba. Jambo lingine muhimu ni kuwa mahakama hii imekusudia na imezingatia pakubwa sana maslahi ya umma. Dirisha hilo la maslahi ya umma ambayo inaitwa public interest katika kimombo. Na maslahi ya umma katika jinsi ambavyo katiba inastahili kutekelezwa na pia kutafsiri kwa katiba kupitia ibara ya 259 kwamba katiba hii lazima itafsiriwe kwa njia ambayo inaongoza nchi katika utawala bora na pia ambayo inaboresha msingi wa utawala chini ya mfumo wa sheria.
Na hapo tuliona majaji hawa pia wakiturejesha shuleni kidogo. Walianza kutupeleka katika katiba ya mwaka 1963 na katiba ya hivi sasa ya mwaka 2010. Walisema kwamba hii katiba ya kitambo ilikuwa haijaweza kuweka wazi wadhifa huu wa naibu wa rais kisheria na mambo ambayo na majukumu ambayo anaweza kufanya. Lakini huyu Jaji Mrima alipokuwa akielezea uamuzi wao kabla ya Ogolla kutoa mwongozo, amesema katiba hii ya hivi sasa haipi nafasi mtu yoyote, sio rais, sio spika wa bunge, kuweza kutekeleza baadhi ya majukumu ya naibu wa rais, na hivyo basi inawalazimu kisheria waweze kutoa mwongozo. Tufafanulie.
La kwanza ni kupongeza majaji wetu kwa mwongozo mwafaka ambao wametoa leo, na mwongozo ambao umetilia kisisitizo kwamba ni katiba na ni katiba. Kwa lile swali ambalo walizungumzia ama umeniuliza ufafanuzi, kitu cha muhimu ambacho Wakenya wanafaa wajue, hii katiba ambayo tuko nayo ni katiba ambayo inaitwa ni transition katiba, na ni katiba ambayo inatuambia kwamba tumetoka muhula ambao sisi kama Wakenya tunajua muhula huo ulikuwa haukukuwa wa njia nzuri, ilikuwa njia ya mabonde na milima. Hii katiba inatupeleka pande mzuri ambao kuna njia ambayo tunaona mahali inatuelekeza. So hii katiba inatumika kama dirisha ama mlango wa kututoa mahali tulikuwa na shida mingi, inatupeleka mahali tunaelewa kwamba kama Wakenya tunaenda wapi. Na ukiangalia vile tulivyokuwa tunaandika katiba yetu ambayo tunaitumia sasa ya 2010, tuliangalia yale maswala ambayo yalikuwa yanasumbua Wakenya. Na swala la kwanza kihistoria kitu ambalo koti ndio haijaingia kwa upana, wakati aliyekuwa rais Moi alimfuta Kibaki, kihistoria wanasema Kibaki alifutwa kwenye airport kiwanja ndege. Ati mzee Moi alimwangalia Kibaki na akamwambia, mimi ndio rais na wewe ni naibu, wewe sio rais, na akapanda ndege akaenda. Wakati alirejea Kenya mwaka wa 93 Kibaki akafutwa kazi. Na inaonesha kwamba hiyo wakati rais ndiye alikuwa msimamizi, na akitaka kumondoa naibu wake hakukuwa mahali popote pa kuambia mtu ama kurifaa kwa mtu. Alikuwa anakuja tu anasema nimemtimua huyu, nimemchagua huyu. Hii katiba ikatupatia nafasi nzuri ya kuweza kupeana tiba na kupeana suluhisho kwa hilo jambo. Tukasema kwamba rais na naibu wake wote wako kwa ile kitu ambacho kinaitwa presidency. Na rais majukumu yake ndio haya, naibu ndio majukumu yake ndio haya, na maswala ambayo naibu anafanya pia kuna ingine rais anaweza muongezea. Na kazi ambayo umepewa kikatiba ni kazi ambayo katiba imekupea wewe, mtu mwingine haezi kuondoa. Na nikirudisha Wakenya nyuma kwa ile mwelekezo ambao koti ilitoa wakati kulikuwa na issue ilikuwa inahusu uteuzi wa judges kusikiza kesi na naibu wa jaji mkuu, koti ilisema kwamba kulingana na katiba yetu, kazi ya kufanya huo uamuzi ni ya jaji mkuu, lakini hii kazi pia imeteua jaji mkuu na naibu wake, na hii kazi ni administrative, kumaanisha kwamba naibu wake anaweza kumsaidia kufanya hiyo kazi. So inarudi tena, ukiangalia mwelekeo wa court, na kwa nini nashukuru court, Wakenya wanaweza ona kuna ile, kwa lugha ya kimombo tunasema consistency na prediction ya hii court wakati inatoa mwelekeo. Kila kitu kinarudishwa kwa msingi ya katiba. Na kitu kingine ambacho Wakenya wanafaa wajue, wakati unasoma Biblia, usisome Biblia na kipengele kimoja. Usisome katiba na kipengele kimoja. Soma katiba kutoka kipengele cha kwanza kwa upana mpaka mwisho. Na wakati unafafanua, kwa sababu jukumu la kufafanua uamuzi wa katiba umepewa kwenye mahakama, wakati unafafanua ama unatoa uamuzi, toa uamuzi kwa manufaa ya wananchi.
Haya, swali la mwisho kwako Joe, hapo kwa katiba tulimwona huyu Jaji Mrima akisema katiba ya sasa ya mwaka 2020 haikukusudia ama haikushughulikia swala la iwapo ofisi hii ya naibu wa rais itakuwa haina mwenyeji. Maswala haya ambayo yanafanywa na naibu wa rais ama majukumu haya hawezi kufanywa na speaker wala rais. Anasema ni nukuu kwa kimombo, the current constitution does not envision a vacant deputy president office because not even the speaker of the parliament or the president can assume the roles of the DP. Hapo kuna mwanya katika katiba yetu ya hivi sasa, pengine katika siku za baadaye ni swala la kushughulikiwa?
Hapana, hakuna mwanya. Kila ambacho katiba imesema kwamba wakati wowote kama nchi lazima tutakuwa na rais, tutakuwa na naibu wake, na kama tutakosa naibu wake, hizi ndizo njia tutakosa naibu wake. Ikapeana kulingana na kipengele cha 150 na ukisoma na 147 na 144, 145 na 46, ikaweka wazi wakati wa kumatua naibu wake. Wakati hiyo ofisi inakosa mwenyewe, vile anachaguliwa mwingine, na ikapeana wakati, ikasema kama ni kumtoa mnamtoa, kama ni rais kumchagua mtu mwingine kwenda kuchukua hiyo nafasi ni siku 14. Kama ni wabunge kule bungeni kumpigia kura, ikapeana siku fulani. So inamaanisha kwa hizo siku ndio mwisho wa sisi kukosa naibu.
Asante. Javas, nataka utufungie na upande wa Rigathi Gachagua. Tumeona wameleta maombi mapya mbele ya mahakama. Kikuu zaidi wamesema huyu Kithure Kindiki huenda kukose mstakabali wa kumwapisha, manake hii tume ya IEBC bado haipo sawa. Vile vile wamesema walikuwa na maombi katika mahakama ya rufaa, maombi ambayo yatasikilizwa Novemba tarehe 6. Hivyo basi wameomba mahakama kusitisha kuapishwa ili waweze kushughulikia masuala haya. Wamejitetea upande wa serikali wakisema kwamba hawa wana rigiji jamani, wamepitwa na wakati, na ikiwa walikuwa na maswali kuhusu Kithure Kindiki wangewasilisha mapema, si leo. Watu wamesema, majaji wamesema wanarejea baada ya dakika 30.
Kweli kabisa Lois. Maombi hayo mapya mawili yanakusudia kujaribu kutetea jinsi ambavyo mahakama hii inaweza weka tena amri nyingine ya kuhifadhi kutoapishwa kwa Rigathi, kwa Profesa Kithure Kindiki kama naibu wa rais. Amri ambayo tayari walikuwa wameinua, na ukiangalia baadhi ya mawakili hasa upande wa bunge wanasema kwamba itakuwa ni kujiletea aibu kwamba mnatoa amri hizo ama mnaziweka kando tena mziregeshe nyinyi wenyewe. Na kuna istilahi mbalimbali ambazo zimeweza kujitokeza katika mahakama na katika uamuzi huu. Kwanza suala la ukatiba, na katika ukatiba mawakili wa Rigathi wanajaribu kusema kwamba ni juhudi la mahakama kuweza kutetea na kulinda haki za kila mtu, haswa kwa njia hii Rigathi Gachagua. Lakini pia katika ukatiba huu inastahili pia iweze kukumbuka kwamba kuna haki za Profesa Kindiki, kuna haki za upande wa bunge na majukumu ya bunge. Kumbuka kwamba katika uamuzi huu mahakama imeweza kueleza kwamba katika ule ugavi na utengano wa mamlaka kuna juhudi ambazo ni za bunge na lazima ziheshimike. Kuna juhudi ambazo na majukumu ambayo ni ya urais na majukumu ambayo ni ya mahakama. Kwa hivyo ukizingatia mambo haya yote sasa hivi, japokuwa ameenda katika mapumziko mafupi,
naam,
sidhani kwamba mahakama itakaporejea katika kikao kwenye mahakama itaweza tena kubatilisha uamuzi wake wapo awali, ama tena kuzidisha ama kurefusha ile amri ya kihifadhi ya kuzuia Profesa Kindiki kuapishwa.
Naam. Asante sana Javas, asante sana John, vile vile mtazamaji wangu nikushukuru sana. Kumbuka hapo ndipo tumefikia, ni kwamba kufikia sasa Kithure Kindiki, naibu rais mteule, ameweza kuondolewa vizingiti na mahakama kuu ya Milimani. Hivyo basi ni kusema anaweza kuapishwa muda wowote kuanzia siku ya hapo kesho. Lakini upande wa Rigathi Gachagua hujakufa moyo, umetoa malalamishi mapya na maombi mapya ya kuweza kusitisha hilo, huku akisema kwamba masuala ya ABC hayajashughulikiwa. Vile vile wanadeti na mahakama ya rufaa tarehe 6, wakiomba jaji ama majaji hawa watatu kuweza kuondoa ama nguvu za Kithure Kindiki kuweza kuapishwa muda wowote kuanzia kesho. Majaji hawa wameomba muda wa pembeni dakika 30, watarejea na uamuzi, na bila shaka tutakuwa tunakuletea kwa njia ya moja kwa moja. Usiende mbali, sisi tunakusanya virago hapa katika hatma ya Rigathi Gachagua, lakini endelea kutazama NTV. Kumbuka dakika 30 uamuzi unatolewa, na baadaye taarifa zetu kwa pamoja na mduara ambao utakuwa unazungumzia kwa undani safari ya Rigathi Gachagua ambayo kwa sasa ama kufikia sasa imekamilika pale Milimani katika mahakama kuu. Kwa heri, mimi ni Lois Ongoi na kutakia jioni njema.
Rigathi Gachagua. Hii serikali tulitafuta na shida mingi sana. Hatuwezi kubali mtu haribu.
Kenyans will be shocked.
Hiyo ikulu nimeweka mitego kila kona. Hapo iko kibarua.
291 members of this National Assembly pended their signatures.
This is NTV.
Karibuni. Hii ndio base ya the best local entertainment. Tell me where my money is.
You don't know what they do to girls like you. Nakwambia Mama Chantel amegeuka kwa mtoto siku hizi. Anabadilisha nguo kama mara 3 kwa siku.
Wakenya, asante kwa kuwa nasi kwa miaka 24. Tunasherehekea kwa kusema asante.